25, Oregon 383. It's an Oregon Supreme Court case from 2014. And I haven't looked at it terribly closely yet, but just from the summary that I've seen, it looks like it could have some guidance there. It's not directly on point, but I think it might give us some ideas about some of the standards that we're supposed to use. I think it talks about legitimate government interest, which may be how we instruct the jury. So that's my ruling with respect to criminal trespass in the second degree. Also, along the same lines of jury instructions, I think we need to talk about jury concurrence. And so the state, if you're not going to elect, I'm going to kind of put the burden on you to come up with some instructions that talk about jury concurrence, and then also a verdict form that reflects, well, this verdict form doesn't probably need to change. Although to be super safe, both might be a good idea, both the jury concurrence instruction and then a verdict form that has both theories reflected for count one, so that it's clear that the jury chose one unanimously over the other.
So would you suggest it would say count one criminal trespass, then in parentheses maybe say lawful order, and then count one criminal trespass parentheses not open to the public, and then the jury, if they so chose, could convict on both theories, but it would still just be one charge overall, of course.
Yes, that's a good point. So I guess we would...
I don't want them to think they now have 4 charges.
Yeah, we would need to tell them that all 6 of them need to agree one way or the other on at least one theory. I think is how that would be worded.
Right. So I would. I'll draw some language and discuss it.
Mr. Gilbert, do you have any thoughts on that?
I was just thinking about the verdict form. I think it could simply say guilty, not guilty, and then below that, the theory, yes, no, for the first theory, the second theory, yes, no, with the numbers of the jurors for each one.
Yeah, I think something like that would probably be safest.
Okay.
So let's throw something together. We can talk about it again. I think that, like I said, I don't know that we'll get to that today.
Sure.
But that's sort of where my head is heading. With respect to count 2, criminal mischief in the second degree, I think that Mr. Gilbert's argument about insufficient evidence of damage is well taken. I actually was having the same thought as I was listening to the testimony, and I had forgotten about State v. Jones. I am familiar with that case, and I think I agree with Mr. Zemmel that it doesn't require evidence of economic loss, and I know that wasn't, or economic damages, and I know that wasn't Mr. Gilbert's argument. His argument doesn't depend on the lack of that. But I do think that the fact that this is art that was arguably damaged, the fact that it was art does play an important role here, and that the smearing of blood on that art does alter it in such a way that it causes physical harm to the art in its purpose, which is to convey this particular aesthetic image, because it alters that aesthetic image. And so I think that it lost essentially its function because of the smearing of blood. And so therefore, I think that there is sufficient evidence of damage in this case. With respect to criminal mischief in the second degree, I also think that there was sufficient evidence of tampering or interference in that it did also require somebody to clean it up. It required some inconvenience on the part of city employees in order to attempt to restore the art to its proper state. Yeah, so I think that that is evidence from which a rational trier of fact could find tampering or interference. So that'll be my ruling. Anything else that we should discuss?
I would just ask the court, if I were to go and do any more research on this issue of whether the constitutionality is for the court or the jury, if I did more research, if I came back with something new to present, is that something the court would entertain?
I
Or
would
you
still consider that.
Okay.
Yeah,
Yummy,
I would.
yummy.
And I think I said criminal mischief twice. I meant for that final piece of my ruling, I was referring to criminal mischief in the third degree. And so that's my goal. Right. Anything else that we should discuss? All right. Does anybody need a break before you bring the jury back in?
I'm fine.
Okay, and then, Mr. Gilbert, let me ask you, who do you know, who's gonna testify first? Is it gonna be Mr. Davis or Mr. Walsh?
Well, Mr. Walsh is not here yet, so it'll be Mr. Davis.
Break real quick, just like.
Yeah, you'll be able
Okay.
to do that. Before you do that though, Mr. Davis, let me just have a quick, discussion with you that I'm required to have on the record about your decision to testify. So you absolutely have the right to testify. That's one of your constitutional rights. You also have another constitutional right, which is the constitutional right not to testify. And so obviously those two things are mutually exclusive. You have to pick one or the other. And it sounds like you're picking the one where you testify. Is that right?
Yes.
Okay. Do you understand that you also do have the right to not testify if you chose to not
Yes.
testify? And do you understand that if you chose not to testify, that I would be required to instruct the jury that they're not allowed to hold that against you?
Yes.
Okay. And do you understand that the decision between whether or not to testify is yours and yours alone to make? Nobody can make a decision for you. You say
Yes,
yes?
I do.
Okay. And did you make that decision on your own?
Yes, I intended to testify the entire time from the, I mean, I was gonna take this to jury trial no matter what.
Okay.
Testify, and from the beginning of the attack on me in City Hall.
Okay, so I am taking from that, you find it very important for the jury to hear your side of the story, and that's your
Yes.
intent all along. Okay.
Yes, I do.
And have you had enough time to, and I don't want you to get into the content of your discussions with Mr. Gilbert, because those are privileged, but did you have enough time to discuss that decision with Mr. Gilbert?
Well, he knew I was gonna testify, we've talked about it, and he's,
Okay, and you don't need to tell me what his advice was,
He's
but I just want to make sure that you had enough time to talk that over with him.
yes.
Okay, all right. Well, I will find that your decision to testify is knowingly and voluntarily made, and I will accept that decision. Let's go ahead and go off the record for Mr. Davis. How long?
Oh, just like 2 minutes.
Okay.
And I actually do have, and he can go back first, I do have a motion regarding his testimony if he is
He
about.
comes back. Okay, all right. Let's go off the record for 5 minutes.
Here's the